Before we begin, a quick and important disclaimer. The following presentation is designed strictly for educational and entertainment purposes and does not constitute professional financial, legal, or tax advice. Navigating the intersection of federal retirement laws, specifically the Employee Retirement Income Security Act, alongside state-specific family law in the Pacific Northwest is highly complex and fiercely litigated. Historical trends indicate that attempting to divide a retirement portfolio without specialized counsel often leads to catastrophic tax consequences. I am not your attorney, and I am not your fiduciary financial advisor. Any case studies discussed today are composites of potential outcomes and public records, formulated to illustrate complex legal mechanisms, and are not a substitute for personalized legal strategy. If you are facing a divorce involving substantial retirement assets in Washington, Oregon, or Idaho, you must conduct your own due diligence and immediately consult with a board-certified family law attorney and a certified divorce financial analyst licensed in your specific jurisdiction. The financial markets and tax codes are constantly evolving, and what protects one estate might completely decimate another. Imagine spending 22 years grinding in the Seattle tech sector. You survived the early 2000s dot-com bust, you weathered the massive 2008 financial crisis, you worked the 80-hour weeks, and you carefully built a 401k portfolio that finally tipped over the $3 million mark. You and your spouse ultimately decide to part ways, but you want to keep it amicable. You sit down at the kitchen table, agree to split everything exactly 50-50, and draft an agreement. Sounds fair. Sounds incredibly simple. But because of a single misplaced paragraph in a heavily regulated document that neither of you fully understood, the Internal Revenue Service steps in and vaporizes over $800,000 of that retirement account in immediate federal taxes, state taxes, and severe early withdrawal penalties. You do not get a do-over. The money is permanently gone. This is not a dark, hypothetical nightmare. Variations of this exact financial tragedy happen every single week in the courtrooms of King County, Multnomah County, and across the entire Pacific Northwest. We are currently witnessing one of the largest generational wealth transfers through divorce in modern history, and your retirement accounts are the absolute epicenter of the battlefield. The statistics surrounding this phenomenon are deeply alarming to financial researchers. Analysts studying wealth preservation during marital dissolution have consistently found that the 401k is often the single largest asset in a marriage, routinely surpassing the equity in the primary residence, particularly in high-growth, high-income corridors like Bellevue, Redmond, and the Portland metro area. Yet, despite its massive value, it remains the most dangerously mishandled asset during a separation. You might think you unequivocally own your 401k. You might think that because your name is printed at the top of the monthly statement, you have the final and absolute say in how it is divided. But the very moment a divorce petition is filed in a county courthouse, federal statutes and local state laws collide in a labyrinth of red tape that can instantly freeze your assets and potentially strip you of decades of hard-earned compound interest. Why does the Pacific Northwest make this financial tightrope even more treacherous? Because if you reside in Washington or Idaho, you are navigating the rigid, often unforgiving rules of community property, where almost everything acquired during the marriage is presumed to be owned equally, regardless of whose paycheck funded the account or whose name is on the login screen. But if you simply cross the Columbia River into Oregon, you are suddenly thrust into an equitable distribution state. Here, judges possess immense, sweeping discretion to divide your assets fairly, which does not always mean equally. A brief 15-minute drive across a state line can completely alter the trajectory of your retirement timeline. Let us examine a composite case study drawn from historical trends in the regional aerospace industry. A couple decides to divorce after 25 years. The husband has a massive 401k from a major manufacturing firm in Everett, Washington. The wife has a much smaller 401k from a local healthcare provider. To balance the ledger, they agree that the husband will simply withdraw a lump sum from his 401k and write a check directly to the wife's personal bank account. The judge signs the decree, and the husband initiates the withdrawal. What their mediator failed to comprehend was that a direct cash transfer from a 401k incident to divorce, without the shielding power of a highly specific federal injunction, triggers an immediate, devastating taxable event for the person pulling the money out. The husband was hit with a massive income tax bill that bumped him into the highest possible federal bracket, plus a strict 10% early withdrawal penalty, because he was under the age of 59 and a half. The wife received her cash, but the husband's remaining retirement stability was completely crippled. This disaster happens because individuals treat a 401k like a joint checking account. It is not. It is a highly regulated, tax-deferred vault governed by federal oversight, and unlocking it requires a very specific, perfectly machined key. That key is called a qualified domestic relations order, and if it is drafted poorly, executed late, or filed in the wrong sequence, your financial future is in grave danger. In this comprehensive masterclass, we are going to meticulously dismantle the entire process of dividing a 401k during a divorce in the U.S. Pacific Northwest. We are stripping away the dense legal jargon to show you exactly how the system operates behind closed courtroom doors. For the U.S. audience navigating this profoundly stressful life transition today, this presentation solves the critical problem of the unknown. We will systematically eliminate the blind spots that predatory legal strategies and aggressive opposing counsels routinely exploit. You will learn the profound operational differences between how a family court judge in Seattle applies community property standards versus how a judge in Portland applies equitable distribution principles, and how your specific zip code absolutely dictates your defensive financial strategy. We will take a deep surgical look into the anatomy of the qualified domestic relations order. You will understand exactly why your standard, court-approved divorce decree is completely powerless to move a single penny from a 401k, and why the corporate plan administrator for your employer holds the ultimate veto power over your carefully negotiated settlement agreement. We are going to deeply examine historical case studies of couples who successfully utilize the little-known federal provisions and specific exceptions in the tax code to access their divided 401k funds completely penalty-free, turning a devastating financial division into a strategic liquidity event. Furthermore, we will explore the critical, fiercely debated timeline of asset valuation. Does your spouse get half of what the account was worth on the exact day you physically separated, the day you filed the legal petition, or the day the divorce is finally formalized by a judge? In a volatile, fluctuating stock market, the difference between those three dates can swing the valuation of a portfolio by tens or even hundreds of thousands of dollars. We will break down historical trends in market fluctuations and illustrate how savvy financial negotiators lock in valuation dates to protect their clients against unexpected market crashes during a prolonged, multi-year legal battle. By the end of this presentation, you will possess a level of situational awareness and strategic foresight that most people do not achieve until after they have already lost a substantial portion of their lifelong net worth. You will know exactly what precise questions to ask your attorney, what hidden red flags to look for in your settlement documents, and how to command your financial future during one of the most destabilizing events of your life. The stakes could not possibly be higher. Your retirement timeline, your long-term peace of mind, and your ultimate financial independence are on the line. To truly grasp the sheer magnitude of this financial vulnerability, we first have to examine the invisible geographic fault lines running straight through the Pacific Northwest. In the year 2026, the local legal landscape surrounding retirement assets is fundamentally split by state borders. You might assume federal law treats all 401k plans uniformly across the country. Federal law dictates how the money is taxed and how it is shielded from creditors, but state family law dictates who actually owns the money when a marriage dissolves. This creates a deeply fragmented system where your exact zip code dictates your defensive posture. Let us look closely at Washington and Idaho. These are strict community property states. Under this doctrine, the law operates on a rigid presumption that any wealth generated during the lifespan of the marriage belongs equally to both spouses. It completely ignores whose name is on the paycheck, whose employer sponsors the 401k plan, and who actively manage the investment allocations. Imagine if you are a software engineer living in Bellevue, Washington. Let us use a case study based on common historical trends in the regional tech sector. We will call them Michael and Sarah. Michael has spent the last 15 years aggressively funding his 401k at a major cloud computing firm. Sarah has operated a freelance consulting business with unpredictable income and no formal retirement vehicle. Michael might look at his 401k statement, currently valued at $1.8 million, and assume that because he worked the long hours, earned the employer match, and made the investment choices, he maintains majority ownership. In a Washington state courtroom, that assumption is a devastating financial vulnerability. From the exact moment Michael and Sarah said their vows, a legally binding invisible fence was erected around Michael's 401k. Every single dollar contributed after that wedding date, along with all the compound interest, dividends, and market growth associated with those specific dollars, is classified as community property. The court views Sarah as a 50% shareholder in that marital growth, recognizing her unseen contributions to the marital enterprise, whether she was running her own business, managing the household, or supporting Michael's career trajectory. But here is where the community property doctrine becomes an absolute logistical nightmare for the unprepared. What if Michael had a pre-existing balance in his 401k before he even met Sarah? Let us say he had $200,000 saved prior to the marriage. That initial $200,000 is categorized as separate property. However, over a 15-year marriage, that separate property has been commingled with marital contributions. It has grown through passive market appreciation, stock splits, and reinvested dividends. You cannot simply subtract $200,000 from the current balance and call the rest community property. That is a massive amateur mistake that could cost Michael hundreds of thousands of dollars. Instead, separating these funds requires complex forensic tracing. Financial experts must obtain historical plan documents and monthly statements going back 15 years to mathematically isolate the exact growth trajectory of that original premarital seed money versus the growth of the marital contributions. In 2026, tracking down archived corporate financial records from over a decade ago often requires subpoenas and aggressive legal discovery. Now let us cross the Columbia River into Portland, Oregon. Oregon completely rejects the community property framework. Instead, it operates as an equitable distribution state. If you are navigating a divorce in Multnomah County, the court is not bound by a strict 50-50 mathematical formula. The primary directive of an Oregon judge is to divide the assets in a manner that is fair and equitable, taking into account the totality of the circumstances. We can observe potential outcomes through another case study. Consider David, an established physician, and Emily, who stepped away from her career 10 years ago to manage their family full-time. David possesses a massive medical practice 401k. In Washington, the marital portion of that account would likely be split directly down the middle. But in Oregon, a judge examines Emily's 10-year absence from the workforce, her diminished future earning capacity, and the stark disparity in their post-divorce financial trajectories. To achieve an equitable outcome, an Oregon judge possesses the sweeping authority to award Emily 60%, 70%, or even a larger fraction of David's 401k to ensure she is not left destitute while David continues to generate a high-income salary. Fair does not mean equal, and understanding this distinction is the absolute bedrock of your negotiation strategy. Once you understand how your state classifies the asset, you immediately run into the valuation date time bomb. This is where historical trends show the most catastrophic wealth erosion during a highly contested divorce. A 401k is not a static pile of cash locked in a vault. It is a living, breathing portfolio of mutual funds, index funds, and company stock that fluctuates wildly with the daily volatility of the global markets. So, what exact day does the court use to lock in the value of the 401k for the purpose of dividing it? Is it the day one spouse physically moves out of the primary residence? Is it the day the formal legal petition for dissolution is filed at the courthouse? Or is it the day the judge finally signs the ultimate divorce decree, a process that can easily take 18 to 24 months in a backlogged family court system? Imagine if Sarah files for divorce in January 2026, when Michael's 401k is soaring at $2 million. They engage in a bitter, protracted legal battle that drags on for 16 months. During that time, a severe market correction hits the tech sector, and the portfolio's value plummets to $1.4 million. If the court uses the date of filing, Sarah might legally be entitled to $1 million, representing half of the original $2 million. But because the account has bled $600,000 in market losses, paying Sarah her $1 million would leave Michael with only $400,000, effectively wiping out his entire financial future. Conversely, if the market had surged, Michael would be the one reaping the exclusive benefit of the passive growth while Sarah's payout remained locked at the lower historical value. The battle over the exact date of valuation is where aggressive opposing counsels earn their retainers. They will strategically argue for whichever date maximizes their client's payout, utilizing complex arguments about passive appreciation versus active contributions made after the date of physical separation. If you do not actively lock in a valuation date early in the negotiation process, you are essentially gambling your retirement on the unpredictable swings of the 2026 stock market. But let us assume you survive the tracing process. Let us assume you successfully negotiate the community property split or the equitable distribution, and you perfectly nail down a mutually agreeable valuation date. You have a signed, finalized divorce decree sitting on your kitchen table, stamped by a judge, clearly stating that your spouse is entitled to a specific percentage of your 401k. Most people breathe a massive sigh of relief at this moment, believing the ordeal is over. They are completely wrong. That court order you are holding is functionally worthless when it comes to actually accessing the funds. If you send that local state court document to the corporate headquarters of Fidelity or Vanguard, they will categorically reject it. They will not move a single dollar. Why? Because state judges do not have the jurisdiction to order a federally regulated corporate plan administrator to break federal tax laws. There is an entirely separate, highly specialized, and deeply misunderstood legal mechanism required to actually breach the walls of a 401k without triggering total financial ruin. It is a document so specific that a single missing comma or a slightly misspelled middle name can result in a catastrophic denial, trapping your funds in bureaucratic purgatory for months or even years while the market continues to shift underneath you. That highly specialized mechanism is legally defined as a qualified domestic relations order, commonly referred to throughout the financial and legal sectors as a QDRO. To truly comprehend why a standard state court divorce decree is entirely powerless to move money out of a 401k, you must first understand the massive, invisible federal fortress built around these specific retirement accounts. Back in 1974, the United States federal government enacted the Employee Retirement Income Security Act, widely known across the industry as ERISA. Congress designed ERISA to fiercely protect employee retirement funds from corporate mismanagement, aggressive third-party creditors, and catastrophic bankruptcies. To achieve this unprecedented level of protection, they embedded a virtually impenetrable shield within the federal law known as the anti-alienation provision. This strict statutory directive unequivocally dictates that your 401k funds cannot be assigned, alienated, or legally transferred to anyone other than you, the employee who actually earned them. If a rogue debt collector attempts to seize your 401k to satisfy a massive medical bill, the corporate plan administrator will immediately invoke ERISA and deny the transfer. Similarly, if a state court judge in Washington or Oregon signs a standard divorce decree ordering your employer to give half of your 401k to your ex-spouse, the plan administrator will again invoke ERISA and outright reject the state-level order. Federal law supersedes state family law every single time without exception. The qualified domestic relations order is the singular, extremely narrow exception to this formidable federal anti-alienation rule. It is a highly complex legal decree that officially creates or recognizes the existence of an alternate payee right to receive all or a portion of the benefits payable with respect to a participant under a federally regulated retirement plan. In the context of a marital dissolution, that alternate payee is the former spouse. However, generating a valid QDRO is not merely a matter of downloading a generic legal form from a discount internet website and hastily filling in the blanks at your kitchen table. Every single corporate 401k plan operating within the United States has its own unique, highly proprietary set of rules, internal limitations, and administrative procedures governing exactly how their specific accounts can be divided. The QDRO drafted for a senior software architect working at a major tech conglomerate in Seattle will look fundamentally different from the QDRO drafted for a regional supply chain manager working at a footwear corporation in Portland. The language must flawlessly align with the specific internal guidelines of the corporate plan, meticulously mirroring their exact legal terminology regarding valuation dates, market earnings, outstanding loan balances, and survivor benefits. Consider a deeply illustrative case study grounded in current year 2026 realities within the Pacific Northwest logistics sector to understand exactly how this plays out in real time. Imagine a couple, Robert and Jessica, who are finalizing a highly contentious, protracted divorce in Pierce County, Washington. Robert holds a substantial corporate 401k valued at approximately $900,000, managed by a major national brokerage firm on behalf of his employer. The court ultimately awards Jessica exactly $450,000 from this specific account. Exhausted by mounting attorney fees and eager to finalize the separation, they decide to bypass hiring a specialized QDRO attorney and instead purchase a cheap, automated document template online for $300. They type in their legal names, the primary account number, and the required 50% split, manage to get a local family court judge to sign it, and proudly mail it off to the brokerage firm, fully believing their financial separation is permanently resolved. What Robert and Jessica do not understand is the rigorous, uncompromising nature of the corporate compliance review process. When the massive brokerage firm receives that QDRO, it does not immediately release the funds to Jessica. Instead, The document enters a mandatory legal review period that can easily last anywhere from 45 to 90 days. Corporate plan administrators employ large divisions of specialized compliance attorneys whose sole professional objective is to protect the brokerage firm from federal liability. If they execute a flawed QDRO and unlawfully distribute protected retirement funds in violation of ERISA, the brokerage firm itself faces catastrophic financial fines from the United States Department of Labor and the Internal Revenue Service. Therefore, these compliance attorneys scrutinize every single syllable, punctuation mark, and mathematical formula embedded within the submitted order. In the specific case of Robert and Jessica, their generic online template completely failed to specify whether Jessica would share in the passive market gains or the devastating market losses that occurred between the exact date of their divorce decree and the actual date the funds were ultimately distributed. Furthermore, the template incorrectly referenced the name of the overarching global parent company instead of the specific regional subsidiary where Robert was legally employed. Finally, the template failed to address Robert's outstanding $30,401,000 loan, leaving the administration completely blind as to whether that debt should be calculated into Jessica's awarded share. Because of these highly technical omissions, the brokerage firm categorically rejected the QDRO. They mailed a formal, heavily redacted denial letter back to Robert and Jessica, plunging their financial separation into an immediate high-stress crisis. This rejection means they have to start the entire bureaucratic process completely over from scratch. They must draft an amended legal order, schedule another hearing in a heavily backlogged 2026 family court system to obtain a new judge's signature, and submit it back to the brokerage firm for yet another 90-day review cycle. Meanwhile, a highly volatile economic event heavily impacts the global tech markets, and Robert's 401k portfolio drops by 22%. Because their original fundamentally flawed QDRO failed to secure a specific mathematically locked valuation formula, Jessica's expected $450,000 payout is now completely unmoored and rapidly dissolving. The massive delay caused by relying on a cheap template has trapped both of them in a devastating financial limbo, actively bleeding tens of thousands of dollars in actual market value, while they fiercely argue in mediation over who legally absorbs the portfolio loss. Historical trends in high-net-worth divorce resolutions consistently reveal that these catastrophic financial delays can be entirely mitigated through a highly strategic, proactive process called pre-approval. Savvy financial attorneys operating at the highest levels of family law never finalize the primary divorce decree without simultaneously circulating a draft version of the QDRO directly to the corporate plan administrator for an unofficial preliminary review. This aggressive strategy forces the compliance attorneys at the major brokerage firms to evaluate the proposed language and flag any proprietary discrepancies or missing loan provisions before the document ever reaches a state judge's desk. By successfully securing this pre-approval status, you effectively guarantee that the very moment the judge signs the final legal order, the plan administrator will execute the financial division flawlessly, permanently locking in the asset value and shielding both parties from the chaotic unpredictability of extended market exposure. Once a fully compliant, flawless QDRO is finally accepted and processed by the corporate plan administrator, the retirement account enters a strictly enforced, highly restrictive phase known throughout the industry as the blackout period. During this critical operational timeframe, the employee who originally earned and funded the 401k is completely locked out of their own account. You cannot execute defensive trades, you cannot reallocate your portfolio to safer bond options if the stock market begins to crash, and you absolutely cannot initiate any new loans or emergency withdrawals. Your entire life savings are essentially frozen in a state of financial suspension, while the brokerage firm's back office mathematically segregates the alternate payee's awarded portion and systematically builds a brand new, completely separate account framework to hold those transferred funds. But the actual creation of that new, secondary account introduces the most critical and potentially dangerous crossroads of the entire marital dissolution process. When the alternate payee finally takes legal control of their newly segregated funds, they are immediately faced with a monumental, highly complex tax decision that most standard financial advisors fundamentally misunderstand. The United States federal government actually provides a hidden, strictly regulated, one-time legal loophole allowing for completely penalty-free cash access to these specific funds, but if you mistakenly check the wrong box on the final corporate distribution form, you will instantly trigger an irreversible tax apocalypse. The specific legal loophole we are examining is buried deep within the Internal Revenue Code under Section 72T2C. Typically, if you withdraw funds from a 401k before you reach the age of 59 and a half, the IRS hits you with ordinary income tax on the total amount withdrawn, plus a highly punitive 10% early withdrawal penalty. That 10% penalty is explicitly designed by the federal government to terrify individuals into leaving their retirement savings untouched. But under this highly specific subsection of the federal tax code, an alternate payee who receives funds directly through a qualified domestic relations order is completely exempt from that 10% penalty. This means that at the exact moment the corporate plan administrator splits the account and creates your new legally segregated file, you possess a one-time, federally protected window to pull raw liquidity out of the 401k without suffering the devastating early withdrawal fine. Imagine if we observe a scenario in the current year 2026. Let us examine the case of Amanda and Thomas, who are navigating a complex divorce across the river from Portland in Vancouver, Washington. Thomas is a senior systems engineer who keeps the primary marital home to maintain geographical stability for their children. To mathematically equalize the total estate, Amanda is awarded $300,000 from Thomas's massive corporate 401k via a flawless, pre-approved QDRO. Amanda is 42 years old. Because the regional housing market is incredibly aggressive, she urgently needs $100,000 in liquid cash for a down payment to purchase a new townhouse in the exact same Vancouver school district. When the corporate plan administrator finally completes the mandatory blackout period, they send Amanda a highly dense, multi-page document known as a distribution election form. This single piece of paper represents the ultimate fork in the road for her financial future. She is presented with several checkboxes. The first standard option is to execute a direct rollover into an individual retirement account, commonly known as an IRA, established solely in her own name. If she checks this box, the entire $300,000 moves seamlessly into her personal IRA. It remains completely tax-deferred, the money continues to grow within the market, and the 401k division is formally and safely concluded. But remember, Amanda needs $100,000 right now to secure housing. If she checks that direct rollover box, moves the full amount into her new IRA, and then immediately withdraws $100,000 from her own IRA the very next week, she commits a catastrophic procedural error. The protective shield of the QDRO only applies to distributions taken directly from the original corporate 401k plan structure. The very second those funds land in her personal IRA, the QDRO exemption instantly and permanently vanishes. By taking the money out of her new IRA at age 42, the IRS will classify it as a standard early distribution. She will owe ordinary income tax on the entire withdrawal, and she will be slammed with a $10,000 early withdrawal penalty, simply because she sequenced the transaction incorrectly. To properly utilize the legal tax loophole, Amanda must check the box for a partial cash distribution directly on the corporate 401k distribution form. She must explicitly instruct the plan administrator to liquidate $100,000 and send it straight to her personal checking account strictly under the QDRO umbrella, and then she can instruct them to roll the remaining $200,000 into her IRA for long-term tax deferral. By executing the cash transaction directly from the corporate plan administrator before the rollover occurs, the 10% penalty is completely and legally waived. However, this is where historical trends show newly divorced individuals making their second massive miscalculation. Penalty-free absolutely does not mean tax-free. You are still legally required to pay ordinary federal and state income tax on every single dollar you withdraw. Furthermore, under rigid federal regulations, whenever you take a direct cash distribution from a 401k, the corporate plan administrator is legally mandated to automatically withhold exactly 20% of the requested amount and send it straight to the IRS as a prepaid tax deposit. If Amanda writes down on the form that she needs exactly $100,000 for her down payment, the corporate plan administrator will mathematically calculate the mandatory 20% withholding. They will carve off $20,000, wire it to the federal government, and physically deposit only $80,000 into Amanda's checking account. Suddenly, she is $20,000 short on her real estate closing date. Her mortgage pre-approval instantly collapses, and the entire townhouse purchase implodes at the 11th hour. To successfully execute this strategic maneuver, you must perform a defensive mathematical calculation, known as grossing up the distribution. If Amanda needs exactly $100,000 in her hand to close on the property, she cannot simply ask for $100,000. She must request a gross distribution of $125,000. The corporate plan administrator takes the mandatory 20% withholding off the top, which equates to $25,000 sent directly to the IRS, leaving Amanda with the exact net sum of $100,000 deposited seamlessly into her bank account. When the tax year finally ends, the corporate plan administrator will generate a specific federal tax document, known as a 1099-R. This is where the final administrative trap is sprung. If the internal coding on that specific 1099-R does not explicitly feature the required alphanumeric designation indicating a QDRO distribution, your certified public accountant will file your taxes, and the IRS automated system will automatically generate a severe deficiency notice demanding the 10% penalty. You then have to enter a lengthy, highly stressful appeals process, providing the original court-certified QDRO and the marital settlement agreement to mathematically prove your legal exemption. It requires absolute, unyielding vigilance from the moment you sign the distribution form until the moment the IRS officially accepts your tax return the following spring. Understanding these precise mathematical formulas and procedural sequencing is the defining difference between securing your post-divorce financial foundation and plunging into a severe liquidity crisis. You have to flawlessly navigate the mandatory withholdings, the potential bracket-bumping income tax liabilities, and the strict IRS reporting codes. The QDRO distribution is a remarkably powerful tool for generating immediate cash during a highly disruptive life event, but it is entirely unforgiving to administrative errors. You must perfectly thread the needle between federal tax code, corporate compliance protocols, and your own immediate cash flow requirements. Yet, all of these complex tax strategies assume that the 401k portfolio consists entirely of standard mutual funds and easily liquidated index funds. What happens when your spouse's retirement account is heavily concentrated in proprietary company stock? In the Pacific Northwest, where massive technology and aerospace conglomerates issue stock as a primary form of aggressive compensation, a standard QDRO cash-out strategy could inadvertently trigger one of the most destructive tax events imaginable. You are about to face the terrifying high-stakes reality of net unrealized depreciation, a deeply obscured tax provision that can either legally shield millions of dollars in capital gains or completely incinerate your settlement if you misunderstand the holding rules. To truly comprehend the catastrophic risks associated with net unrealized depreciation, we must first look specifically at the geographic and economic realities of the Pacific Northwest. This region is not merely a geographic location. It is a global epicenter for massive technology conglomerates, multinational retail headquarters, and legacy aerospace manufacturing. In the current year of 2026, companies operating out of Seattle, Bellevue, and Redmond routinely structure their employee compensation packages heavily around proprietary company stock. They match 401k contributions not just with raw cash, but with shares of their own corporate entity. Over a 10 or 20-year career, this results in a retirement portfolio that is dangerously top-heavy, where a massive percentage of the overall wealth is tied directly to the performance of a single company ticker symbol. Let us examine a highly detailed case study based on historical trends in the King County technology sector. Consider Christopher and Melissa, a couple navigating a high-net-worth divorce in Seattle. Christopher holds a title as a senior systems architect at a major cloud computing firm. Over his 18-year tenure, his corporate 401k has ballooned to a staggering valuation of $3 million. However, upon closer forensic inspection by a specialized financial analyst, a critical detail emerges. $2 million of that total portfolio consists entirely of highly appreciated proprietary company stock. This is where the concept of the cost basis becomes the most important mathematical figure in their entire legal negotiation. The corporate plan administrator did not simply deposit $2 million into Christopher's account. Over the past 18 years, the employer systematically purchased those shares at various intervals when the stock price was significantly lower. The actual historical purchase price of those specific shares, which we refer to as the cost basis, might only be $400,000. The remaining $1.6 million represents pure, unadulterated market growth. Under federal tax law, that massive $1.6 million chunk of growth is legally defined as net unrealized appreciation. In a standard uncontested divorce scenario, a mediator might look at the total $3 million account and simply award Melissa $1.5 million to achieve a mathematically equal split under Washington's community property laws. Melissa hires a standard attorney, they draft a standard qualified domestic relations order, and they submit it to the corporate plan administrator. Melissa, acting on the advice of a generic financial planner who lacks specialized training in complex divorce taxation, instructs the corporate plan administrator to liquidate her awarded share of the company stock inside the 401k and execute a direct, seamless rollover into her own personal traditional individual retirement account. By executing this seemingly logical, highly common maneuver, Melissa has just inadvertently committed one of the most destructive financial blunders possible in a high-asset marital dissolution. The very second she instructed the plan administrator to sell that company stock inside the protective shell of the 401k, or the moment she rolled those specific shares into an IRA, the protective shield of the net unrealized appreciation was permanently and irreversibly vaporized. Why is this so devastating? Because of how the Internal Revenue Service categorizes long-term taxation. When money sits inside a traditional IRA, every single dollar pulled out during retirement is legally classified as ordinary income. If Melissa waits until she is 65 and begins taking distributions from that rolled over $1.5 million, she will be subjected to the highest applicable ordinary income tax brackets of her future retirement years. In 2026, those top federal brackets can easily consume over 35% of her wealth, and if she remains in a state that implements new wealth or capital gains taxes, the erosion becomes even more severe. Now, let us examine the strategic, highly sophisticated alternative utilized by elite financial litigators. Instead of blindly rolling the company's stock into an IRA, Melissa's specialized counsel would structure the QDRO to mandate an in-kind distribution of the actual shares. This means the shares are not sold. They are physically transferred directly from the corporate 401k into a standard, non-retirement, fully taxable brokerage account held solely in Melissa's name. When you execute an in-kind transfer utilizing the NUA provision, the IRS tax mechanics completely shift. In the exact year of the transfer, Melissa is legally required to pay ordinary income tax, but she only pays it on the original cost basis of the shares she receives, not the massive current market value. If she receives half of the stock, her share of the cost basis is $200,000. She pays standard income tax on that $200,000 immediately. However, the true power of this strategy lies in the remaining $800,000 of her awarded growth. That specific growth is now permanently locked into the long-term capital gains tax framework. When Melissa ultimately decides to sell those shares from her taxable brokerage account 5, 10, or 20 years down the road, she will not pay the crippling ordinary income tax rate. Instead, she will pay the significantly lower, highly preferential long-term capital gains tax rate, which historically maxes out at 15 or 20% for most investors. By recognizing the existence of the net unrealized appreciation and perfectly sequencing the in-kind transfer through the QDRO, Melissa effectively legally shields hundreds of thousands of dollars from the highest tiers of federal taxation. However, executing an NUA strategy requires immense tactical precision and carries substantial inherent risks. Firstly, Melissa must possess the immediate, liquid cash available outside of the retirement accounts to pay the IRS the required ordinary income tax on that initial cost basis during the tax year the transfer occurs. If she is cash poor from the ongoing divorce litigation, she simply cannot afford to trigger the NUA provision. Secondly, by holding heavily concentrated stock in a single technology company, she is assuming massive, undiversified portfolio risk. If the technology firm experiences a catastrophic market failure, a prolonged regulatory investigation, or a severe corporate restructuring, the underlying value of her settlement could plummet before she has the opportunity to safely diversify the assets. The NUA strategy is an incredibly sharp scalpel, but in the hands of an untrained practitioner, it can easily sever an essential financial artery. Up to this exact point, we have meticulously dissected the defined contribution framework. We have mapped the vulnerabilities of the 401k, exposed the critical structural flaws of generic legal templates, and illuminated the hidden tax loopholes carefully guarded by corporate compliance divisions. A 401k is transparent. You can log into a portal, view a dashboard, and observe the exact monetary value down to the final decimal point. But the financial landscape of the Pacific Northwest harbors a completely different, far more opaque, and infinitely more complex retirement vehicle. What happens when your spouse does not merely have a 401k, but instead holds a traditional legacy-defined benefit pension from a massive regional aerospace manufacturer or a state government entity? You cannot simply log in and divide a pension by 2. You are no longer dividing a static pile of current cash. You are attempting to calculate, divide, and legally secure a completely invisible stream of future income that might not begin paying out for another 2 decades. If your legal team applies the valuation mathematics of a standard 401k to a legacy pension plan, or if they utilize the incorrect actuarial mortality tables during the high-stakes negotiation phase, you could unknowingly forfeit millions of dollars in guaranteed lifetime payouts. To understand why legacy defined benefit pensions are so heavily litigated in the Pacific Northwest, we must fundamentally separate them from the 401k structure we just dismantled. A defined contribution plan like a 401k has a known exact present account balance. You are dividing a clearly visible pile of accumulated capital. A defined benefit pension, however, is a contractual obligation from an employer to pay a former employee a specific monthly income stream starting at retirement and continuing until the day they die. You are not dividing a pile of cash. You are attempting to calculate the marital value of a ghost asset that does not technically exist as liquid capital today. In the year 2026, this region remains deeply entrenched with legacy pension plans, heavily concentrated in the legacy aerospace manufacturing hub stretching from Everett down to Renton, alongside massive state government public employee retirement systems in both Washington and Oregon. Imagine if we look at a complex case study involving James and Elizabeth, who are dissolving a 25-year marriage in Snohomish County, Washington. James has spent 32 years working on the assembly lines and moving up into management for a legacy aerospace giant. Under the corporate defined benefit pension plan, James is scheduled to receive a monthly payout of $8,000 when he officially retires in 4 years. Because Washington operates under strict community property laws, Elizabeth is entitled to a 50% share of the pension benefits that were actively earned during the exact time frame they were legally married. But James worked for the company for 7 years before he even met Elizabeth. This is where the mathematical battlefield is drawn, utilizing a specific formula known in legal circles as the coverture fraction or the time rule. To establish Elizabeth's exact legal share, a forensic accountant must determine the precise coverture fraction. The numerator of this fraction is the total number of months James participated in the pension plan while married to Elizabeth. Let us mathematically say that is exactly 300 months. The denominator is the total number of months James participated in the pension plan overall, which is 384 months. You divide 300 by 384, resulting in a coverture fraction of roughly 78%. This means 78% of James's future $8,000 monthly pension is legally classified as community property. Since Elizabeth is entitled to half of the community property portion, she is awarded 39% of the total future monthly payout. However, arriving at that percentage is merely the beginning of the tactical negotiation. Once Elizabeth knows her percentage, she faces 2 entirely different potential outcomes for actually retrieving that value. And the path she chooses will dictate her financial security for the rest of her life. The first option is an immediate present value buyout. Under this strategy, Elizabeth does not want to wait 4 years for James to retire, nor does she want her financial survival tethered to his lifespan. She wants to be compensated for her share of the pension right now, utilizing other marital assets. To achieve this, the legal teams must hire specialized pension actuaries. These actuaries utilize complex mortality tables to statistically predict exactly how long James is expected to live based on his current age, health status, and historical demographic trends. They calculate the total amount of money the pension would likely pay out over his projected lifetime, and then they apply an economic discount rate based on 2026 federal interest rates to reduce that massive future sum down to a single, lump sum present value figure. If the actuaries determine the present value of Elizabeth's specific pension share is $400,000, James can legally buy her out by trading another asset. He might relinquish his legal claim to $400,000 of the primary marital home's equity, allowing Elizabeth to keep the house free and clear while he retains 100% of his future pension. This immediate offset method provides a clean, permanent financial break, but it relies entirely on the accuracy of actuarial science and the prevailing interest rates. If interest rates are significantly high during the 2026 calendar year, the mathematical present value of the pension drops considerably, meaning Elizabeth would receive far less equity in the buyout than if rates were lower. The second option is deferred division, where Elizabeth chooses to wait until James formally retires to begin receiving her 39% share of the monthly checks. If the pension is a private, corporate plan governed by federal law, this requires drafting another qualified domestic relations order. But drafting a pension QDRO is infinitely more dangerous than drafting a 401k QDRO because of the devastating survivor benefit traps hidden within the fine print. Imagine if Elizabeth chooses the deferred division route. The judge signs the QDRO, and the Aerospace Corporation accepts it. 3 years later, while still actively employed, James suffers a fatal heart attack. Because James died before he actually retired and triggered the pension payouts, his standard pension completely evaporates. Unless Elizabeth's legal counsel explicitly negotiated and formally included a highly specific federal provision, known as a qualified pre-retirement survivor annuity within the strict text of the QDRO, she receives absolutely nothing. Her 39% share vanishes into the corporate ether, leaving her completely destitute. Furthermore, what if James successfully retires, the pension begins paying out, and then he passes away 5 years later? Again, the payments will instantly cease upon his death, unless Elizabeth was explicitly designated as the irrevocable surviving spouse under a post-retirement survivor annuity. Corporate plan administrators do not automatically grant these survivor protections to an ex-spouse simply because a divorce occurred. They must be fought for, mathematically calculated, and legally mandated within the court order. Including these survivor benefits often permanently reduces the total monthly payout amount while James is alive, creating a fierce point of contention during the mediation process where every single dollar is aggressively contested. The landscape becomes even more treacherous if you are dealing with state public employees, rather than corporate workers. If your spouse is a teacher, a police officer, or a municipal worker participating in the Washington State Department of Retirement Systems, or the Oregon Public Employees Retirement System, you are operating entirely outside the realm of federal law. Government pensions are explicitly exempt from the Employee Retirement Income Security Act. You cannot use a federal QDRO to divide a state pension. Instead, you must draft highly specialized, state-specific court orders, often called domestic relations orders or property division orders, which are governed strictly by state administrative codes that change rapidly and drastically across the Pacific Northwest borders. Understanding this jurisdictional divide is the only way to prevent your legal documents from being rejected by the state retirement boards. Yet, as complex as dissecting a legacy aerospace pension or a state retirement system might be, it pales in comparison to the strategic nightmare that unfolds when you attempt to balance these highly illiquid retirement vehicles against the single most emotionally charged asset in the entire marital estate. You can run the actuarial math flawlessly and execute the perfect coverture fraction, but the moment you attempt to trade future pension income for current equity in a Pacific Northwest real estate market that is experiencing unprecedented volatility, you introduce a catastrophic risk known as asset class mismatch. When a spouse blindly trades the long-term tax-deferred security of a retirement portfolio just to keep the keys to a heavily mortgaged house, they unknowingly set a trap that routinely results in total post-divorce bankruptcy. To understand this catastrophic risk, we have to pull back the curtain on the single most dangerous cognitive bias in family law. It is the deeply ingrained, emotionally overwhelming desire to maintain the primary marital residence. In the year 2026, across the highly competitive real estate corridors of the Pacific Northwest, the family home is much more than just a shelter. It represents neighborhood stability for the children, proximity to elite school districts in places like Mercer Island or Lake Oswego, and a physical anchor during a period of massive personal upheaval. Because of this profound emotional attachment, individuals routinely sit across the mediation table and willingly surrender their legal rights to a massive, tax-advantaged 401k portfolio just to secure sole ownership of the house. On a standard balance sheet, trading $1 million in home equity for $1 million in retirement funds looks like a perfectly equitable, mathematically balanced 50-50 split. In reality, it is a devastating financial illusion that historical trends show is one of the leading causes of post-divorce financial ruin. Let us deeply examine a case study that perfectly illustrates this asset class mismatch. Imagine a couple, Daniel and Rebecca, navigating a divorce in Kirkland, Washington. Their financial estate essentially boils down to two massive assets. They own a beautiful home with exactly $1.2 million in pure equity, and Daniel has a corporate 401k also valued at exactly $1.2 million. Desperate to keep her children in the same school district, Rebecca aggressively negotiates to keep the house. Daniel agrees, walking away with his entire 401k untouched. They sign the decree, and the lawyers finalize the paperwork. Rebecca feels an immense sense of victory because she secured the home. However, the crushing reality of liquidity and asset categorization is about to completely shatter her financial foundation. Rebecca traded a liquid, income-producing asset for an intensely illiquid, capital-consuming liability. A 401k is a dynamic financial engine. Even during volatile market periods, it historically generates dividend yields, compound interest, and passive market growth. It requires absolutely zero maintenance, no monthly upkeep, and no property taxes. The house, on the other hand, is a physical structure that constantly degrades and aggressively consumes cash. By taking the house, Rebecca has unknowingly absorbed the entire burden of King County property taxes, which in 2026 are exceptionally high. She is now solely responsible for skyrocketing homeowner insurance premiums, utility surges, and inevitable catastrophic maintenance failures like a $30,000 roof replacement or a flooded basement. Furthermore, the valuation comparison is fundamentally flawed due to embedded tax liabilities. Daniel's $1.2,401,000 consists entirely of pre-tax dollars. When he eventually retires and withdraws that money, he will have to pay ordinary income tax on every single distribution. Therefore, his account is not actually worth $1.2 million in spendable cash. If his future effective tax rate is 25%, the true spendable value of his asset is roughly $900,000. Rebecca's home equity, however, is generally shielded from taxes upon a future sale due to the federal primary residence capital gains exclusion, assuming she meets the ownership and use tests. This means their supposedly equal trade was actually heavily skewed from the very beginning, entirely because their standard mediator failed to calculate the net present value of the assets after adjusting for future tax liabilities. But the tax disparity is just the tip of the iceberg. The real danger that routinely bankrupts newly divorced individuals is the refinancing trap. In almost every divorce scenario where one spouse keeps the house, the court mandates that they must refinance the underlying mortgage to completely remove the ex-spouse from the financial liability of the loan. This is where the macroeconomic climate of 2026 becomes a lethal weapon. When Daniel and Rebecca originally bought their Kirkland home years ago, they secured a highly favorable, historically low interest rate. But to remove Daniel from the mortgage, Rebecca must apply for a brand new loan under current 2026 market conditions, where interest rates have fundamentally shifted the lending landscape. Suddenly, the exact same house with the exact same loan balance costs thousands of dollars more every single month just in interest payments. Rebecca is now attempting to cover a massive, newly inflated mortgage payment, astronomical property taxes, and aggressive maintenance costs, all on a single income stream. She becomes what financial analysts refer to as house poor. All of her wealth is trapped inside the drywall, completely inaccessible, while her monthly cash flow bleeds out to zero. If she needs emergency cash, she cannot simply withdraw $10,000 from the living room wall. Her only option is to take out a highly restrictive home equity line of credit, driving her even deeper into high-interest debt. Let us trace the potential outcomes of this scenario over a 5-year timeline. Daniel's 401k, left completely untouched and experiencing standard historical market growth, continues to compound. His net worth steadily climbs. Rebecca, suffocating under the immense carrying costs of the property, slowly drains her small emergency savings just to keep the lights on. Eventually, a major medical bill or a temporary job loss triggers a catastrophic default. Facing imminent foreclosure, she is forced to sell the Kirkland home under extreme duress. Because she is selling out of desperation, she takes a lower offer, pays massive real estate agent commissions, and absorbs the severe transaction costs. After paying off the new, high-interest mortgage, her final cash payout is a fraction of the original $1.2 million she thought she secured. By trading the 401k for the house, she unknowingly engineered her own financial collapse. To successfully prevent this disaster, elite family law attorneys and specialized forensic accountants utilize a strategy called tax-affecting the marital estate. Before anyone is allowed to trade a 401k for real estate equity, the financial experts apply complex algorithms to calculate the exact, post-tax, liquid value of every single asset. They project the carrying costs of the home against the post-divorce income streams to mathematically prove whether the spouse keeping the house can actually afford the macroeconomic realities of a 2026 mortgage. They force the negotiation out of the emotional realm and strictly into the mathematical realm, ensuring that you are not blindly trading a heavily taxed, dynamic investment vehicle for a cash-draining physical structure. However, even if you secure the absolute best forensic accountant in the Pacific Northwest, and even if you perfectly tax-affect the entire marital estate, you are still inherently vulnerable to the most malicious and destructive tactic utilized during a bitter separation. What happens when the spouse who legally controls the corporate 401k realizes they are inevitably going to lose half of their massive portfolio to you? What stops them from logging into their online portal at 2 o'clock in the morning, right before the divorce petition is formally filed, and intentionally draining the account through massive, obscure financial loans, essentially destroying the asset before the court can even freeze it? You are about to enter the darkest corner of marital dissolution, exposing the precise mechanisms of financial sabotage and the critical emergency legal injunctions you must deploy immediately to prevent your retirement from being permanently erased. The period of ultimate vulnerability in any marital dissolution does not occur inside the courtroom. It occurs in the silent, highly volatile window of time immediately preceding the formal filing of the legal petition, and in the chaotic weeks just after the papers are served. We live in the highly digitized financial landscape of 2026, where corporate plan administrators have intentionally designed their user interfaces to be entirely frictionless. You no longer have to call a broker or sign physical paperwork to move massive amounts of wealth. A spouse can simply open an application on their smartphone while sitting in a coffee shop, authenticate with facial recognition, and initiate catastrophic structural changes to a lifelong retirement portfolio with a few taps on a screen. This frictionless access is mathematically necessary for modern banking, but during a bitter separation, it becomes an incredibly dangerous weapon of financial sabotage. Historical trends across family courts in the Pacific Northwest consistently demonstrate that when a spouse realizes they are inevitably going to lose 50% of their most valuable asset, human psychology often devolves into sheer financial vindictiveness. Imagine a highly illustrative scenario based on frequent litigation patterns occurring right now in Spokane, Washington. We will examine the case of Richard and Olivia. Richard is a senior operations manager at a regional logistics corporation and holds a 401k currently valued at $800,000. Tensions at home have reached a breaking point, and Richard discovers that Olivia has secretly consulted with a prominent family law attorney. Knowing that a formal divorce filing is imminent, Richard decides to execute a scorched earth financial strategy. Late at night, he logs into his corporate retirement portal. Under federal regulations, an active employee is legally permitted to take a loan against their own 401k balance, typically capped at $50,000 or 50% of the vested account balance, whichever is less. Richard requests the absolute maximum $50,000 loan. Because he is the sole account holder, the corporate plan administrator automatically approves the request and wires the liquid cash directly into an obscure, individual checking account solely in Richard's name. A week later, Olivia officially files for divorce and serves Richard with the legal paperwork. When her forensic accountant finally demands the financial disclosures and looks at the 401k statement, the total balance appears normal on the surface. However, buried deep in the liabilities column is a massive $50,000 loan obligation. Richard has essentially siphoned off a massive chunk of the highly liquid cash and replaced it with a debt instrument that must be repaid with his post-tax future earnings. During the formal mediation, Richard's attorney will argue that the distributable balance of the 401k is now significantly lower due to the outstanding loan. Furthermore, Richard proceeds to take that $50,000 in cash and systematically transfers it into decentralized, highly volatile digital assets, making it exceptionally difficult and prohibitively expensive for Olivia's legal team to trace and recover. From a strict legal standpoint, a judge in Washington state will look at this transaction and definitively label it as the dissipation of marital assets. The court will clearly recognize that Richard intentionally wasted or hid community property in anticipation of the divorce. The judge will mathematically attribute that missing $50,000 directly to Richard's side of the final balance sheet, theoretically restoring Olivia's equitable share. But this is where the brutal reality of the 2026 financial system shatters the illusion of courtroom justice. A judge's decree is merely a piece of paper. It represents a legal victory, but it does not magically conjure missing cash back into existence. If Richard has successfully hidden the money in untraceable digital ledgers, or recklessly spent it on speculative ventures that completely failed, Olivia possesses a mathematical victory, but suffers a severe actual loss. You simply cannot squeeze liquid equity out of a mathematically bankrupt estate. To permanently neutralize this devastating vulnerability, elite family law attorneys deploy an aggressive, multi-tiered defensive protocol the absolute moment they accept a high net worth case. The first layer of defense is the state-level injunction. In jurisdictions across Washington, Oregon, and Idaho. The very act of filing a petition for dissolution often automatically generates a mutual, temporary financial restraining order. This heavily enforced legal doctrine strictly prohibits either spouse from selling, transferring, borrowing against, concealing, or in any way disposing of any property, real or personal, without the explicit written consent of the other party or a direct order from the judge. It theoretically freezes the entire financial chessboard. However, the catastrophic flaw in this system, which amateur attorneys routinely fail to comprehend, is the profound disconnect between the local county courthouse and the massive corporate financial institutions. A judge in Multnomah County might sign a perfectly drafted financial restraining order, but the compliance division of a massive brokerage firm headquartered in Boston or New York has absolutely no idea that this local court order even exists. Unless the corporate plan administrator is explicitly notified, they will continue to process Richard's loan requests, his withdrawal applications, and his aggressive portfolio reallocations as if everything is completely normal. The state-level restraining order only allows the judge to punish Richard after the sabotage has occurred. It does virtually nothing to physically prevent the corporate software from executing his malicious commands. This critical operational gap requires the immediate deployment of the second, far more powerful layer of defense, known as the notice of adverse interest. This is a highly specialized legal directive drafted by a qualified domestic relations order attorney and served directly to the legal compliance department of the corporate plan administrator. This incredibly powerful document explicitly invokes the Employee Retirement Income Security Act and formally places the massive corporate entity on official legal notice that a divorce is pending and that the spouse is claiming a distinct marital interest in the retirement funds. The moment the compliance division receives and logs this formal notice, their internal liability protocols are immediately triggered. They will instantly place a hard administrative freeze on the entire 401k account. Richard will be completely locked out of his own portfolio. He will be structurally prevented from initiating loans, executing premature cash withdrawals, or altering his beneficiary designations until the corporate administrator receives a finalized, judge-certified QDRO resolving the dispute. The concept of beneficiary designation introduces another silent, incredibly dangerous vector for financial sabotage. Under standard federal law, a spouse is automatically the beneficiary of a 401k plan. If the account holder dies, the surviving spouse inherits the entire portfolio. However, a highly contested divorce in the modern legal system can easily drag on for 24 to 36 months. What happens if the account holder passes away during this prolonged, high-stress litigation period before the final divorce decree is actually signed? A vindictive spouse might attempt to forge a spousal waiver and secretly change their primary beneficiary to a sibling, a new romantic partner, or a private trust, intentionally attempting to disinherit their estranged spouse while the divorce is still pending. If the notice of adverse interest is not securely in place, the corporate administrator might inadvertently pay out millions of dollars in death benefits to a newly named third party, forcing the surviving spouse to engage in years of agonizing, fiercely expensive federal litigation to claw the money back from the new recipient. You must view your retirement portfolio not as a static bank account, but as a heavily contested military objective operating in a deeply hostile legal environment. The moment the reality of a divorce materializes, you are in a race against the clock to physically sever the opposing party's access to the financial levers of power. You must aggressively weaponize the temporary restraining orders, perfectly execute the corporate notifications, and legally bind the hands of the plan administrator before a single dollar can be moved in the dark. But even if you perfectly execute these defensive legal maneuvers, even if you freeze the accounts flawlessly, and even if you successfully shield the portfolio from the malicious intent of your spouse, you are still entirely exposed to an external macroeconomic threat that you absolutely cannot control. What happens when you spend 2 years fighting for half of a massive corporate retirement plan, only to wake up and discover that the massive Pacific Northwest corporation holding your money has suddenly filed for Chapter 11 bankruptcy? To understand the true peril of corporate insolvency during a marital dissolution, we must first separate financial myths from federal law. When a major employer in Seattle or Portland announces a catastrophic Chapter 11 bankruptcy in the year 2026, the immediate psychological response is sheer panic. You assume your entire 401k has been liquidated to pay off aggressive corporate creditors. Fortunately, the Employee Retirement Income Security Act strictly mandates that all 401k assets must be held in a legally separate, fiercely protected federal trust. The corporate entity does not technically own the money in your 401k. They merely sponsor the overall administrative plan. If the massive Pacific Northwest Corporation completely collapses, external creditors cannot legally pierce the veil of that federal trust to seize your retirement funds to satisfy corporate debts. The actual capital is fundamentally safe from corporate liquidation. However, that federal shield only protects the structural integrity of the trust itself. It offers absolutely zero protection against the underlying investment risk of the specific assets held inside that trust. This is where historical trends in regional technology and aerospace sectors reveal a terrifying, wealth-destroying vulnerability. Imagine a highly detailed 2026 case study involving William and Sophia, a couple finalizing their bitter divorce in King County, Washington. William holds a massive $2,401,000 at a prominent regional technology firm. Because of aggressive corporate matching programs and lucrative employee stock ownership provisions, 75% of his entire retirement portfolio is heavily concentrated in the proprietary stock of his specific employer. Just as Sophia and William sign their final mediation agreement, legally locking in Sophia to receive exactly $1 million from that specific 401k account, the technology firm is suddenly hit with a massive federal regulatory fine and files for immediate Chapter 11 reorganization. The corporate stock price plummets from $150 a share down to $3 a share in a matter of 48 chaotic hours. The federal trust holding the 401k remains perfectly intact, but the actual liquid value of Williams' portfolio is instantaneously vaporized. The account drops from $2 million to just over $500,000 in a single week. Because their finalized legal settlement explicitly promised Sophia $1 million extracted specifically from that 401k balance, William is now mathematically incapable of fulfilling the state court order from that single asset. Sophia is legally entitled to pursue the remaining $500,000 from William's other separate assets, potentially forcing him to aggressively liquidate his newly purchased post-divorce home or completely empty his remaining emergency cash reserves. This catastrophic wealth destruction highlights the absolute necessity of defensive asset diversification before a divorce decree is ever officially stamped by a judge. Elite financial litigators will systematically force the employed spouse to liquidate highly concentrated company stock inside the 401k and reallocate those vulnerable funds into stable, broad market index funds the very moment the initial physical separation occurs, effectively shielding the entire marital estate from a single company implosion. But the bankruptcy nightmare becomes infinitely more complex and devastating when we pivot away from 401k plans and examine legacy-defined benefit pensions. If a massive Pacific Northwest manufacturing corporation goes bankrupt, they often entirely default on their long-term future pension obligations. When this catastrophic default happens, a federal agency known as the Pension Benefit Guaranty Corporation is statutorily forced to step in and assume total administrative control of the failed pension plan. The PBGC acts as a massive safety net for the American retirement system. However, the PBGC absolutely does not guarantee your full, originally promised pension amount. They are legally bound by strict, federally mandated maximum payout limits that fluctuate significantly based on the exact calendar year the plan collapses and the exact age of the employee when they officially begin taking monthly distributions. Consider a secondary historical scenario involving David and Emma. David worked for a legacy aerospace firm and secured a legally promised pension of $12,000 a month. During their intensely litigated divorce, Emma was awarded 50% of that stream, mathematically translating to $6,000 a month for the rest of her life. They based their entire post-divorce financial survival and real estate purchasing power strictly on these specific numbers. Suddenly, the aerospace firm completely collapses under massive supply chain debt, and the PBGC legally takes over the defined benefit plan. Under current 2026 federal administrative limitations, the PBGC might cap David's maximum allowable benefit at just over $7,000 a month, completely overriding and legally disregarding the original corporate promise. David's total pension is instantly slashed by the federal government from $12,000 down to $7,000. Because Emma's qualified domestic relations order entitles her strictly to 50% of the actual paid benefit, her monthly survival income drops violently from $6,000 to $3,500 overnight. The original mathematical foundation of their entire divorce settlement is permanently destroyed, and because the divorce is already legally finalized in the state court system, Emma has absolutely no legal mechanism to drag David back into mediation and demand more separate money to offset the massive PBGC reduction. She is simply forced to unilaterally absorb the catastrophic, lifelong loss of reliable income. Furthermore, when a massive corporation enters Chapter 11 bankruptcy, the entire administrative apparatus governing their internal retirement plans is thrown into complete operational chaos. The internal corporate compliance departments that typically process your legal QDROs are often gutted by immediate, massive employee layoffs. The entire plan administration is frequently transitioned to entirely new third-party financial institutions. If you have a pending QDRO sitting in a corporate compliance inbox the exact day a bankruptcy is publicly announced, your legal document falls into a terrifying bureaucratic abyss. The transition from the bankrupt company to the new successor plan administrator can trigger a massive operational blackout period, lasting anywhere from 6 to 18 agonizing months. During this immense administrative freeze, your QDRO will absolutely not be processed. You cannot extract your legally awarded funds, you cannot roll your money into a safe individual retirement account, and you remain entirely trapped in a state of complete financial paralysis while the broader global stock market continues to fluctuate wildly outside of your control. When the successor administrator finally takes full legal control of the defunct corporation's retirement infrastructure, they institute entirely new, highly proprietary compliance protocols. The original QDRO your attorney meticulously drafted to align with the old company's specific rules will almost certainly be categorically rejected by the new administrative entity. You are essentially forced to start the entire costly negotiation and legal drafting process completely over from scratch, returning to a severely backlogged 2026 family court system to secure a newly amended state order. This is exactly why aggressive legal counsel will constantly monitor the corporate health of an opposing spouse's employer. If there are industry whispers of regional corporate instability, mass executive resignations, or plunging quarterly earnings reports, they will demand an immediate, heavily expedited QDRO processing schedule, bypassing standard mediation timelines to physically extract the marital funds before the corporate doors are permanently padlocked. Let us assume you successfully navigate the immense complexities of the Pacific Northwest legal system. You seamlessly bypass the strict community property traps of Washington and the subjective equitable distribution hurdles of Oregon. You perfectly execute the highly dangerous net unrealized appreciation tax strategy. You actively avoid the catastrophic real estate asset mismatch, and you successfully extract your funds long before a corporate bankruptcy freeze can trap your wealth. The money is finally sitting safely in your personal individual bank account. You breathe a massive sigh of relief, fully believing the exhausting multi-year legal war is finally over. You rebuild your personal life, purchase a new home, and completely sever all emotional and financial ties with your former spouse. But precisely 24 months later, a certified letter arrives in your mailbox. It is an official heavily bolded notice from the United States Internal Revenue Service, and they are demanding an immediate, highly aggressive federal audit of your entire post-divorce financial estate. What hidden, deeply obscured tax reporting mechanism did your legal team completely fail to file? And how can a single missing federal tax form from 3 years ago legally grant the federal government the ultimate authority to aggressively seize your newly rebuilt wealth? The answer to that terrifying question lies deep within the archaic, heavily automated infrastructure of the Internal Revenue Service and a highly specific piece of paperwork known as IRS Form 5329. When you successfully executed that qualified domestic relations order and extracted your penalty-free cash distribution from your former spouse's 401k, the corporate plan administrator generated a tax document called a 1099-R. This document reports the massive withdrawal to the federal government. In a perfect, flawless administrative ecosystem, the Corporate Compliance Department places a specific alphanumeric code in Box 7 of that 1099-R, signaling to the IRS computers that this specific withdrawal is legally exempt from the crippling 10% early withdrawal penalty due to the divorce decree. But historical trends in thousands of post-divorce tax audits reveal a devastating operational reality. Corporate plan administrators frequently make clerical errors. They routinely code that 1099-R as a standard early distribution, completely omitting the vital QDRO exemption code. When your standard, non-specialized tax preparer files your annual return the following spring, they often overlook this tiny single-digit coding error. They fail to manually attach IRS Form 5329, which is the absolute required mechanism to legally claim your QDRO exception and mathematically prove to the federal government that you do not owe the penalty. Because the IRS operates on a massive automated underreporter system, Human eyes do not initially review your tax return. The federal computer system simply matches the erroneously coded 1099 R from the massive brokerage firm against your personal 1040 tax return. It instantly detects a massive discrepancy, registers that you pulled $100,000 out of a retirement account before the age of 59 and a half, and automatically assumes you are legally liable for the 10% penalty plus additional income taxes. However, the IRS rarely notifies you immediately. The federal government has a statutory look-back period, and they often wait up to 36 months to issue a formal deficiency notice, known as a CP 2000. Imagine if we examine a current 2026 case study involving Mark and Sarah, who finalized a deeply contentious divorce in Boise, Idaho 3 years ago. Sarah was awarded $200,000 in cash from Mark's 401k to purchase a new home. The transaction was completed, the divorce was closed, and Sarah moved on with her life. Now in 2026, Sarah opens her mail to find a CP 2000 notice from the IRS demanding $20,000 for the unpaid early withdrawal penalty, plus 3 years of aggressively compounding federal interest, plus a substantial understatement penalty. The total federal demand exceeds $30,000, due in 30 days. If she cannot produce the original, court-certified QDRO, the original settlement agreement, and immediately hire a specialized tax controversy attorney to aggressively litigate against the IRS Appeals Division, the federal government possesses the unilateral statutory authority to place a hard levy on her new bank accounts, garnish her current wages, and place a federal tax lien on her newly purchased Idaho home. A single administrative coding error from 3 years ago has returned to completely annihilate her rebuilt financial independence. This catastrophic potential outcome perfectly illustrates why your divorce is never truly finalized the day the judge signs the decree. The post-divorce rebuilding phase requires an entirely new team of specialized professionals. You can no longer rely on the seasonal tax preparer who handled your simple joint returns during the marriage. You must immediately retain a certified public accountant who possesses deep, specialized expertise in complex divorce taxation, asset division reporting, and federal penalty abatement. They must forensically review every single tax document generated in the year of your divorce to ensure the corporate plan administrators accurately reported the massive movement of your retirement wealth. But the IRS is not the final hidden trap waiting in the shadows of a Pacific Northwest divorce. There is an even darker, far more tragic vulnerability that routinely destroys generational wealth, and it revolves entirely around the legal supremacy of beneficiary designations. When you finally secure your share of the 401k or successfully roll it over into your own newly established individual retirement account, you are immediately required to name a new primary beneficiary. This designates exactly who inherits the wealth if you suddenly pass away. In the chaotic, emotionally exhausting aftermath of a brutal 2-year legal battle, newly divorced individuals routinely forget to update these critical forms. They might spend $10,000 hiring a new estate planning attorney to draft a brand new last will and testament, explicitly leaving all of their newly secured assets to their children. But under strict federal law, and reinforced by numerous United States Supreme Court rulings, the beneficiary designation form on file with the financial institution completely supersedes any state-level will or trust. Federal contract law overrides state probate law every single time. Consider the potential outcomes of this oversight. A newly divorced father in Seattle secures his $1.5 million IRA. He writes anew while leaving everything to his 2 daughters. Tragically, he passes away in a sudden accident 6 months later. Because he forgot to physically log into his brokerage portal and remove his ex-wife's name from the digital beneficiary form, the massive financial institution is legally obligated to write a $1.5 million check directly to his ex-wife. His daughters receive absolutely nothing from the retirement account. His ex-wife legally absorbs the entire estate they just spent years tearing apart in family court, and the daughters have virtually no legal recourse to claw that money back because the corporate administrator simply followed the strict letter of the federal contract. To permanently bulletproof your new financial reality, the absolute final step of any marital dissolution must be a comprehensive estate planning overhaul. The very week your divorce decree is finalized, you must execute a coordinated, synchronized update of every single financial lever in your life. You must strip your ex-spouse's name from your retirement accounts, your life insurance policies, your transfer-on-death real estate deeds, and your emergency bank accounts. You must establish a new revocable living trust to shield your independent assets from the incredibly public, highly expensive state probate courts, ensuring your wealth transfers seamlessly and privately to your exact intended heirs. You have now mastered the incredibly dangerous, highly volatile mechanics of the 401k and the legacy pension. You understand the profound jurisdictional differences between Washington's community property and Oregon's equitable distribution. You know exactly how to weaponize the Qualified Domestic Relations Order, how to legally exploit the net unrealized appreciation tax loopholes, and how to aggressively shield your portfolio from internal financial sabotage and external corporate bankruptcy. But while we have spent hours meticulously dismantling these traditional retirement vehicles, we have completely ignored the single largest, most heavily guarded source of hidden wealth currently dominating the Seattle and Portland corporate landscapes. What happens when your spouse's true wealth is not sitting in a transparent 401k, but is instead intentionally obscured inside a rolling multi-year schedule of unvested restricted stock units and complex executive compensation packages that the standard family court formulas completely fail to calculate?